also examining Aripo's role along with sustainability and use of technology to engage stakeholders. Let's begin with introducing esteemed moderator. We are honored to have Professor Dr. Anindya Sircar from NALSAR University of Law. He is a chair professor of IPR and director of the NC Banerjee Center of IPR Studies, with expertise in IP management, acquisition, and corporate integration. Welcome, sir. Yes, sir. Dr. Anindya Sircar? Yeah. Welcome, sir. We are joined by Mr. Ashok Narladkar, from a patent agent at Creighton Corporation with over 14 years of experience in patent drafting, prosecution, and analysis. He holds a PhD in polymer chemistry and has worked as a postdoctoral researcher at CNRS Paris. Welcome, sir. Now I would like to invite Mr. David Sampson. Mr. David Sampson is the manager of Intellectual Property Group at Apollo Tyres Limited. He specializes in IP risk analysis, management, and innovation. He plays a key role in aligning intellectual property strategies with organizational goals, ensuring effective IPR management to support the business growth. Welcome, sir. Next, we have Mr. Jagannathan, IPR lead at Tata Motors, a registered Indian patent agent and a lawyer. He brings to the table 10 years of experience in patent management and litigation support, having worked with Lakshmi Kumaran and Sridharan, IP Pro Services, and ABB India. Welcome, sir. Finally, I would like to welcome Mr. Said Ramadhan. He is a senior patent examiner at Aripo. He brings his expertise in biotechnology engineering and chemical process engineering. Having joined Aripo in 2011, he was promoted to senior patent examiner in 2016 and has a background in forensic science in Zanzibar Ministry of Health. Welcome, sir. With this, I would hand over the session to our moderator. Sir, you can continue. Thank you.
Good evening, everybody. It's so wonderful to be here at this juncture, and I'm really happy that so many of you have gathered for this session. And it's a happy occasion for me that I'm meeting some of my old friends after a long time and sharing the panel with them. So that gives an extra amount of happiness to me.
We are really sorry. We are also joined by Mr. Samit Gambhir, who is the Senior Vice President and a Group Head Legal at UFLEX Limited. Has 35 years of experience in legal compliance and risk management. He has held leadership roles at DCM Shriram, KPMG, and Schneider Electric, contributing to various national and industry level committees. Welcome, sir. Welcome, Samit, sir.
Mr. Gambhir was always in our mind, but we just missed him in the stage, and then we could finally gather him back. He was there? I was there. That's the reason I realized myself. That's really exciting to hear. So our theme of this panel is, designing a dynamic IP strategy. And that's very, very important and pertinent in today's world because, it is the same yarn which you are hearing everywhere. There's rapid innovation, there is, technological advancement which is happening. So if there is a rapid innovation, technological advancement which is happening, the IP system also has to keep up with it. Remember, the law, including IP, has always been a follower. Technology is the forerunner. So we need to transform, trying to make changes, being a follower, to keep up with this advanced system. So the IP system cannot be static, it needs to be dynamic, and which is flexible and adaptive. So when I say that, we have a wonderful panel which will focus on exploring the practices, the strategic approaches, which can design to this dynamic IP system, focus on the changes. So when I say dynamic, it doesn't mean that, you know, it's a set of repository of procedures and principles. It is dynamic and it keeps changing as the need goes by. So let's explore the practices with this wonderful panel. Now we have a wonderful team here. I would like to request, each of them with a very small opening remark, if you can start. Let's start with Ashok.
Good afternoon all, and I'm glad to be part of this panel to talk about dynamic IP system, how it is helpful, benefit to creators, to the businesses, and as well as to the individuals. So difficult to touch on all the parameters or topics, but I will highlight a few topics which I feel are important to have in the part of a dynamic IP system. And to start with, the thing is that the dynamic IP system should be adapting or adaptability to the technological development. Starting from yesterday morning till I think finishing this conference, everybody talks about artificial intelligence. So we have technology development across areas, including the artificial intelligence, hydrogen, energy, green energy, sustainability, and blockchain. So if we have a dynamic IP system in place, it will ensure the protection to these different inventions and also get benefited to the IP creator as well as business. Next one topic is, basically point is about enhancing the global competitiveness. So what happens is that when you have dynamic IP system in place, it will ensure and empower the business as well as individuals to stand in global markets, and also it will help the basically the stakeholders to stand in the meet the international regulations. The third point about the protecting the against the emerging threats. So when the technology advancement happens, the challenges also increases. The challenges in terms of the patent trolling, the counterfeited products, or digital piracy. So if we have the proper responsive flexible IP system, it will accommodate those challenges to deal with that. And lastly, dynamic IP system, responsive IP system will also encourage the innovations and collaborations, particularly when you have joint ownership, licensing agreements, and when there are multiple stakeholders are involved. So you have clear-cut guidelines through this dynamic IP system to accommodate all the stakeholders to meet their need, their demand.
Samson, what would be your opening remarks very quickly?
Yeah, maybe I will, good afternoon everyone. I will have the perspective from an organization. So he has touched upon various aspects. So from an organization level, the dynamic IP should be looking into the various changes that's happening in and around. So it is already there in the past, but to a great extent, the rate of changes are quite high these days or in the coming future days. So on that aspect, there should be a lot of focus on the landscapes. IP should be taken care. And also previously, the licensing part within the scope of a technology, maybe it is a talk of the legal, but now R&D should also pitch in with respect to the legal licensing part when it should also be connected to the business strategies. So that is one of the aspect, and also the workforce, all the scientists and engineers behind all the creations, they will be disrupted frequently because they make some creation, then it goes to a cycle and it get into the market commercialized, but they will not have much of a wait of a time. Again, they need to be motivated to make more new IPs. So in this run, again, due diligence should be the topmost priority. As you create something, due diligence should be the one which should be taken care on the priority list. So these are my opening remarks. So this creates a dynamic IP system which is more vibrant compared to the past world. Thank you.
Maybe Jagan?
Yeah, hi. Thank you, Dr. Sircar, and thank you, GIPC, for inviting on such a interesting topic. So my opening remarks in this would be that when we say dynamic IP systems, obviously like Dr. Sarkar put up, it is about the IP system keeping up pace with the rapid changes in the technology advancements and whatnot. Now, that is not just applicable at the global and the national level, but it is also applicable at the company level. And being someone from an in-house, it is very important for the companies to ensure that their IP system is also dynamic and it is keeping in pace with how the company is progressing. So there has to be an alignment with how the IP system is functioning. It has to be in line with how the company is progressing. So that way there has to be a dynamism within the IP functioning of a company. Yeah, that would be my opening remarks. Thank you.
Sid, you would like to add something?
Thank you very much for giving me this opportunity. I think I'll join my colleague here. I think for my side, I'll just give a bit of introduction of our system, which I think is different from my colleagues. Our system is more of a registry system, so we have a different responsibility there. And then one of the main issue is to make sure that our system is dynamic, going together with the development on the world in the technologies. And that was actually, we would also touch a bit about what exactly what we are doing in terms of keeping our system in update. And the most important one is like recently, we had almost like amending our laws, which related to the patent and the design, to make sure that it's in tied with the current technology that's going through. Thank you.
Submit.
Thanks, sir. I think we have really seen the dynamics changing in the IP sector. You know, in the last, if you talk about last 15, 20 years, we have seen tremendous changes. The dynamics have completely changed actually in terms of IP. Right from, you know, the views of the courts now, they have started taking stricter views on the IP protection. You know, there was a time when the courts were not taking very serious view, or they're trying to find out a mediocre way kind of a thing, or medium way. But now the courts have actually started taking, plus technological advancement, collaboration with, you know, institutions, collaboration with, you know, community, with activists and all. So I think we have seen tremendous change in the dynamics of IP, and it's radically changing actually. So I think we have a lot to talk about it, you know, when we'll speak.
Thank you very much for the opening remarks. I wish, now let's do a little bit of deep diving. So let's start with the fundamentals. You know, my first question to you, Ashok, is there really a need for a dynamic IP strategy, or we are good with this static system? If there's a need, why there is a need?
So basically, so the way we are doing traditionally, and the things are progressing from technology point of view, from challenges point of view, I think the way we are, like, for example, earlier, the situation or the challenges we have not seen, but we are seeing those challenges, and to accommodate those challenges, to deal with those challenges, and also to accommodate the technological advancement, we have to adapt ourselves. Even for example, if you see the recently patent officer also cooperating that way. Recently, always we have a struggle about filing the statement of work in Form 27 in India. And recent changes is that you can do it once in 3 years. So patent officer also cooperating, understanding the pain of the businesses and the industry. So if they are doing, we have to do, and then it will be cooperative manner, we can progress, right?
Well, thank you very much. And even Form 27 has not only, once in 3 years now, it has been made far easier, the lesser entries to fill in. It's really, it used to be a big pain, all of us know where. So when I go to you, Samson, since we all believe that we have to keep changing, reminded of Wordsworth, the old order changes, yielding place to the new, and God fulfills him in many ways. So to fulfill this, what kind of strategies, you would suggest?
So maybe taking a common example within, from the IP perspective, but from a cricket perspective, from our childhood we have been seeing the test and the ODIs. very suddenly there came the T20, and it was very receptive, and it was adapted also. So similarly, the disruptions always doesn't seem to be too much demanding, in the sense it is making something much more better than the past. So with respect to the strategies, so as a benefiter, it can be from a creator point or the end user from the society. So I will touch upon some basic points on the creator level. So some of the strategies is to have within the dynamic IP system to foster an innovation culture. So fostering an innovation culture, these are some of the words which can be, if you really audit it, we will not be getting really is that been fostered. So here, when you want to foster the culture, the creator should be well aware of the changes in the market, and it should go through the organization's strategic goals or the targets. So if a creator or an engineer or a scientist, he is very keen in making new things, but his efforts are not that validated with respect to the organizational targets, that is going to be somewhere wasted, or the resources are not well utilized. So creating that culture and well connected to the target is something in the dynamic IP system we have to take care. And the system itself will be giving more opportunities for the creator to know what's happening really in the world outside. And all the facets of this artificial intelligence and the information flow, one themselves can also understand what's really happening. So that is one point. And second is the prioritizing of IP creation and protection. So here comes, in the previous time, I would generally say, organizations create and protect and maintain. Now, in this flow, there should be an involvement of your CTO, and he should be aware what are the jurisdictions coming into play, and also the business strategy team. And if there is a decision to stop some of the business products and bring up new products, then that patents need not to be maintained, trademarks need not to be maintained. So the business strategy team, the legal team, and the marketing team has to be pitching at certain intervals, and there should be good licensing with them. So this brings out a good opportunity for the IP team to work towards various functions within an organization. And finally, leveraging the IP for business growth. So this is on the licensing part. So previously, most of the manufacturing organizations, as today's discussion, previous discussion also touched upon, the process are mostly the trade secrets. So maybe looking into the EV space, now licensing would be something that can accelerate or catalyze the new ventures to make things faster. So on that space, IP should be leveraging considering the growth of the organization. So in this era, IP team should have the right tools, and there should be a strong team, empathizing team, to work with the scientists, also to the top management, combining all the efforts to reach out to the relevant stakeholders within. So this is from the creator's point of view. And when we talk about the outside, looking outside, the system, the dynamic IP system should also have a faster responding time with respect to the prosecutions, and also some of the other aspects we'll touch upon in the later time. Thank you.
I can't agree more with you that on the point that which I've seen, that these changes have to be top down. It has to trickle from the top, from the CDO, CEO level. It's not bottom-up approach doesn't work. So I couldn't agree more with you. Now, going to Jagan. Jagan, you have spent quite a lot of time in the automobile industry. So it'll be nice if you can share some of your insights, some of the challenges which you feel, not only the good part, maybe the not so good part also, which you face when you want to have some changes or build new strategies.
Right. Thank you for the question. So that is actually, I'll like to add a few insights from the automotive sector, and especially from the in-house perspective. Of course, these are my personal views, and these are not my company's views or what I want my company to do or something. So typically when it comes to dynamic system, so what happens is in the in-house system, it is very important to maintain that dynamism, because like all of us spoke about, the technology is moving at a rapid pace. For example, in the automotive sector, we are seeing that earlier there was there was internal combustion engine driven vehicles. Now we see adoption towards electric vehicles, and going forward there may be fuel cell based vehicles, and then hydrogen internal combustion engine vehicles. So that way the technology is also moving forward. So along with that, there is supposed to be movement of the IP system also of the organization. So this may be challenging a bit, particularly for an in-house system. The reason is that IP is not something that is the department. It is easy for the department to get sidetracked from the mainstream functioning of the organization. We see, for example, sales and marketing or the engineering teams always being in the thick of actions. They always know what is happening, where they are supposed to go. Whereas when it comes to IP, so typically IP is not something that comes to the mind of the board or the C-suite every day in and day out. Unless something goes horribly wrong, that is the last thing on their minds. So in situations like this, it tends to be easy for the IP system also within the company to be a little off the loop, go into their shell, or sort of get closed with regard to how the company is going. So in that case, it becomes a reactive kind of organization or a function, which which can simply stop at receiving disclosures from the inventors and see, we will file and we will support the inventors, and that's where our job ends. Or maybe do some filing and prosecution, that's where our job ends. It is very easy to be that way, but that will not be aligned with how the company wants it to be. So in that case, the onus is to ensure that the IP system is aligned to the business strategy. Now, so for that, the IP system and the company should be on the same page to see how things go and ensure that both are on the same page. Now, how do we do that? Once, let's say, the business strategy is known and now we want to be aligned, how we do that? At the function level also, there are challenges. For example, now the IP system also has to, let's say, be on a continuous learning path, continuously upskill, unlearn and relearn. For example, now in-house professional can not keep saying that I am an expert in engine, I am an expert in transmission, so I'll deal with only inventions which are coming from there. When it is something about battery or fuel chemistry or electrical motor design, that is not my forte, and I will not do that. That cannot be the case, and there has to be a constant unlearning, relearning and upskilling that is required. And that way, with the change in the business strategy, the portfolio also has to change. Like Mr. Sampson mentioned, the pruning of the portfolio has to take place along the lines of how the company goes. So in an ideal world, we would like to maintain all the patents that we have filed. But with the limited budget that the company has, we have to see what to renew, what not to renew, what to let go. So all these things have to be kept in mind. And that way, there has to be a lot of synergy, lot of collaboration, lot of these challenges have to be overcome by the IP function, particularly to stay relevant and to stay dynamic and stay valuable to the organization as a whole. That would be my take on it.
Thanks, Jagan. I just wanted to make a mention here that we are all speaking about the value part of IP. Okay, that's how to increase the value. But IP management has another important point, which is the risk part. How do you de-risk your position, your business, in terms of IP? So whereas the mantra is very simple, maximize your value and minimize your risk. So there is a need for systems to come in, systems to build in, where your potential threats are at least near zero, if not zero. So with that, let me ask Sumit that in doing this kind of stuff, this kind of process, there are several stakeholders. What is your thought on how each stakeholders can engage and contribute towards a meaningful outcome?
Wonderful. I think it's very important when we are talking about the IP dynamism and we're talking about the stakeholder. I think it's something which is very important nowadays. It's inclusive part of it. As you're saying, the risk management actually is basically de-risking your portfolio, de-risking your litigation risk in terms of that. If you are actually involving all the stakeholders, and I think the stakeholders are very simple. Your inventor, from your inventor to your employees, to your management, all these are your internal stakeholders. These are to be on the same page, and it's very difficult to engage them on the simple things, saying that this is something is here, and you are going to be the part of it because as a stakeholder, as an important stakeholder. But not only that, we're talking about the court nowadays. As I told you, the court have started taking a different views nowadays. We have seen that Supreme Court judgment of, I think it's very old judgment of 2011, where the court said that intellectual property should be a property. I mean, it's not a fundamental rights because it was moved from Article 300A as a constitutional right. But someone can't be deprived of their property. So court have taken that view that it is actually a property for you also. So courts are one of the stakeholders. The way courts are interpreting the things, the way courts are actually taking serious issues, giving injunctions now, and trying to protect your IPs. So they are one of the very important stakeholders for us to protect our IPs. Then I will say government, of course, policy makers, government, everyone has to play a role, and we really have to, there are people activists, there are NGOs, there are policy makers who regularly in touch with the government. For example, we from our chambers, PhD chambers, WICCI, CIA chambers, we keep on talking to the government also in terms of policy making. So these are important stakeholders which actually help us to strategize our IP policy, to strategize the dynamics of the IPs, and the ultimate user, of course. Your vendors, your users, your customers give you a lot of insights about it. So they are very important stakeholders which we should forget. So they also give you a lot of insights about it. How do you protect your IP? What are the things that you should keep in mind? What are the things that you should change? So I think the role of stakeholders is very, very important in its overall strategizing your dynamics of IP.
Thank you, Sumit. Now let's look at Syed's view. Syed, Aripo is a very big organization. Okay, it has its, hands, tentacles over multiple countries. So how is Aripo looking at this? What kind of strategies, what kind of work, how are they looking at this?
Okay, thank you very much for that question. I was just checking my colleagues here. I think if you consider the IP ecosystem, so we have the creation part where they're coming from the companies. So may talk about the enforcement, but also there's a protection part whereby the IP office is responsible for provide that in terms of the certification of protection. So as our organization is a RIPO, I think my colleague yesterday, using the opening remarks, he mentioned this is an intergovernmental organization which is responsible for providing protection in terms of registration of the grant of the patent and the registration of utility model, trademark, and the design. And the organization is kind of a testimony of collaboration, because it's formed of more than like a 22 member state. So it's 22 countries that come together, knowing the complexity of the IP system itself, and then the kind of resources required to put a strong and dynamic IP system. That's why they came out with this idea of having the regional organization responsible for taking care of the registration management of all the IP right within the region. And right now we have a 22 member state. So in that case now, for us to manage in terms of the dynamism of the system, that's why we have a different legal instrument that is specifically designed for a specific type of IP right. For example, we have what called the Harare Protocol, specifically designed to cater for the protection of the patent, utility model, and design. I mean, those inventions. And then you have another protocol called the Banjul Protocol, specifically designed to care for the issue of the protection of the trademark. So those are the systems, the different, and of course other ones, like for example the one for plant variety protection. So those are different aspects of the legal system that we have designed to make sure that we are getting protection of all these things. So in case now we have our stakeholder from different area of the different part of the world, they are free. They can get their protection within our region, simple by just filing application through our RIPO system and choose all those 22 countries that they are ready to get into. And again, I think most of us, we know the challenge of the law in terms of some of their countries, because of the dynamism of the system, of the IP system right now. Changing the law sometimes is taking forever. But because of this system that we're having, our law, they keep reviewing every year, checking what is currently upside there, what is new, what is changing in terms of the environment, in terms of the IP system, and therefore we have a very flexible system whereby if anything come out, we are ready to incorporate in our systems so that we take care of it during so that's why we have every year thing to review, and in terms of the approval procedure for those amendments, it's become very easy within 2 years, 1 year, within every year you get that kind of approval. So it makes our system quite up to date. That's why I say dynamic based on what is needed into the market. As we speak right now, I think the whole of last year we went through the overhaul for example the legal system for protection of the patent, to make sure that what is currently is there. Of course, the issue of the artificial intelligence coming through. So those are things that we are considering during. So the system is very user friendly, flexible, and dynamic based on the. So that's how we are doing, and based on the collaboration between those 22 countries that we agree. Let's have one system that covers the whole region of that. Thank you.
Thank you, Seth. That was really, a lot of insight into the system, because I guess most of us are not that familiarized with how our repo functions. With that, let me come back to your show. When it comes to technology, and we're talking about technology advancement, technology changes, the most important component becomes patents. And the most important part of the patent is claims. Okay? I believe many others may also agree with me. So, how do you think this claim drafting and related aspects are going through a change because of this technological eruptions or disruptions?
So when we file a patent application to any patent office, the 3 criteria patent needs to understand is: first is novelty, inventive step, and industrial applicability. Now that is from patent office to grant the patent. But from applicant side, what we are looking in claims. So we need to look carefully that even though patent office give me grant for that particular invention, is my claim enforceable? So whenever we do the patentability study, whenever we come across relevant prior art, whether it's non-patent, patent literatures, we try to overcome those prior art in our claims. So we want to, our claims should be differentiating over the prior art. But in order to differentiate that, we should not be adding something to claims or to independent claim that is not enforceable. First thing, so that is during the preparation of the application. Now during the prosecution, so even if we are not able to find the relevant prior art, we did not come across, examiner will do. Now examiner is during the examination report, he is citing some relevant prior art which we have not come across, and now in order to overcome those prior art which examiner has cited, we can bring anything from the specification or from the dependent claims to claim 1 to make my claim 1 novel, inventive over the prior art. But whatever we are bringing from the specification or from the dependent claim to claim 1 or to independent claim, we need to make sure that I may be able to differentiate my claims over the prior art, but then is it enforceable? So I am coming from the chemical industry and we have these challenges. Sometimes it is possible to have a differentiating claim, but then is not enforceable, particularly where the IP respect in some countries is not up to the mark. That is one thing. During the litigation, what happens is that when you have chemical compositions, products or processes, when they are doing the measurements and when there is a litigation, the court will ask the independent laboratory to measure those properties, those measurements. Now, applicant, they don't have a control over what the independent laboratory does. So so until and unless there is clear guidelines of the property measurement, for example, in chemical invention, we standardly use the American ASTM method. So ASTM method, this, and the year. If that method is there, whether it's an independent laboratory or whoever, they can clearly use that method and then measure the properties. But imagine that there is no standards used and independent laboratory has to measure the properties, we don't have a control. So I think claim drafting to enforce the patent particularly is very, very critical.
Thank you, thank you. So while we are looking at strengthening this, strategies in various ways, claim is one of them. Something, do you think in the process of strengthening the IP strategy, what's the role of policies or, sustainability, inclusivity, or, does harmonization in various centers help? What are your thoughts on those?
So all these aspects, as you told, plays a very huge role in bringing a dynamic IP system. So policies are the backbone, and also the legal and the regulatory are the framework over in the IP system or any system that works. So coming to a dynamic system, flexibility of the policies within the era of artificial intelligence or the enhancement in the biotechnology area. So all these things need to be included within the scope of a policy. For that, the policy should be more flexible and adaptive. So here, when I mean to be flexible is that it is not more yielding rather than it is more vibrant or resilient to include the new inventions or new matters that can be further improving the policies to make a revised policy. So in the jurisprudence, when looking into the precedents, so these matters of IP are not something that has been replicated from the past instances. These are totally new. So the references were to make a new policy should be also be licensed or to be taken feedback from the creators as well, or include them when making the new policies. So these are some of the aspects with respect to the policies. And it should also have a balanced protection. Most of the times when the creators' rights are protected, sometimes it goes more for monopoly, but the public should also have access to it in the invention and to improve above those aspects. And secondly, coming to the inclusivity part. So this is basically within Indian context, expanding the participation of all the regime, wherein in the technology space, those who are oriented technology will have more accelerated growth. So in inclusivity, those who are not able to catch up to that pace should also be given chances to understand the IP system, and also to have their pie, or they are also more creative, which we do not know. So this dynamic IP system should be also taking care of a society where they are also able to pitch in and provide their contributions to the dynamic IP system. And on the capacity building, so when I was in my school days or in the college days, IP was not a matter of in the syllabus then. But in most of today's context, IP is a syllabus matter. At least some part of the IP has been covered in the colleges. So there should be, again, it should be coming to a +2 level. There should be an open certification program, something like that, which can give at least, because those minds are very clear and innocent, so they can learn and try to respect much more in their future. So this is some area which the government can give some insights to the lower schooling levels. CPAM and NIPAM is doing great, but this can be also be taken care into an open certification level. And the other 2 points are mostly on the sustainability. So when dealing with the sustainability, the development should have more looking into a longer term of the returns. When you talk about new sustainability or carbon neutral, but business sustainability is at stake. So most of the panelists will be agreeing it. So business cost has gone up. So when new inventions come, the scaling up and the sustainable scaling up and the commercialization of those aspects also need to be looked into. So there should be consensus, like all of a sudden the carbon neutrality will be taking a back hit for the organizations. So these are some of the points I would like to share with you. Thank you.
Thank you. That was quite a helpful insight. Jagan, when we get into a system, we all have strategies, okay? We keep changing some of the strategies. In some part, we stick to our old pattern. The most important part is the strategy effective? Okay, how do we measure success? Is there a matrix we can say that, okay, my earlier strategy was good, this is bad, or vice versa, the earlier strategy was bad, this is good. How do we know that it's effective? Is there a way, some matrix? How do we measure success in this?
So the measuring is actually a very tricky part, particular entirely in the IP domain, you cannot clearly ascertain, measure the quality of a patent or measure the likelihood of the patent getting granted or what is the value of the patent. Everything is a vague thing. So measurement, everything, it comes with its own subjectivity. So measuring the effectiveness of an IP system also is difficult that way. One broad metric that I could think of in this is how aligned your IP strategy is with regard to your organizations. That could serve as one metric for measuring the effectiveness of the IP system. So what I mean by that is that I'll give an example. How aligned are you with the company strategy? Your company, why your company is doing IP? Why your company is in the business of filing or doing something with the IP? First of all, we have to be aware of that. And how aligned you are with that particular strategy is what we need to know. For example, whether your company is in the IP game, let's say for just for numbers, or is it for some defensive purpose, for offensive purpose, for licensing, or let's say it's a combination of everything. Your IP strategy has to, your IP system has to change along with that. For example, if your organization is in it only for the numbers game, for the bragging rights, to show to the world that you are an innovative company, then your IP system should be focused on building the numbers. There, of course, quality also is important, but then how to build the numbers, that is more important in that case. If it is for, let's say, for a defensive purpose, in that case, your IP strategy should be very much focused on what is going in the product, what is going in your service, how do I best ensure that it has the protection. If it is, let's say, for example, an offensive purpose, you want to go after infringers, you want to catch infringers. So in that case, your numbers may not matter as much, but you have to identify the right inventions, ensure that they are given the best possible protection, the broader scope of protection, and accordingly how you take care of your patents also matters because of that. For example, you do a directed prosecution, or let's say you do your competitive landscapes to ensure that you know what your competitor is doing and align your portfolio along the lines of what he is doing. That becomes important. If it is, let's say, a hybrid of everything, then your strategy IP system should also be a hybrid one. For example, let's say you have a graded system saying that you have tiers of inventions. If it is of very good quality, and so you treat it as tier 1 and you do so and so, you give it the best possible protection, you use the best attorneys, and if it is in tier 2, then you do so and so. So that way you should have your IP system, how effective it is, how valuable it is to the organization that it is serving. That is a reliable indicator, reliable measure of the effectiveness of the system. That would be my take.
Thank you. The most successful companies usually classify their IP in three buckets. It's either defensive, monetizing, or strategic. Defensive are the ones which are your bread and butter. You can't do business without them. Monetizing could be enforcing, licensing and other things. Strategic IPs are IP which you're not using today, but you feel that tomorrow, in the future, they have a lot of potential. Now you need to revisit each bucket at your desired intervals. And this is again dynamic. What is strategic today can become defensive tomorrow. So you decide, what is the interval you should revisit them and look after that. Now, in going forward, Samit, we are looking for an answer, maybe, how to leverage other aspects or other potential aspects to make a better strategy. Do you think, education, collaboration, public-private partnership, or stuff like that helps?
You're asking me a tough question now, complex questions. I think it really, really helps, and we have seen this also nowadays. In the last few days, we have really seen the growth of these collaboration. Institutional collaboration is very, very successful. We have seen that, incubators and all. Then we have seen joint innovations is also very successful. At the same time, when we are talking about, collaborating with institutions wherein we have seen the, open source system, for example, open source code. We have seen the wonderful example of Linux Foundation, They are doing wonderful job actually with the help of entirely collaboration, nothing else. If you have your IP, you have your copyright, you give to them, they protect your copyright, and then it is all involved in the system. So I think they have been doing very wonderfully. Then I've seen many institutionals or the colleges partnership or collaboration have been very successful. We have been they have given a lot of value to it, a lot of inputs to it, and a lot of IPs are generated out of that. Plus, if I connect it with the stakeholder versus the collaboration, etc., then the enforcement of IP is very important. Actually, sometimes it becomes very, as you were saying, the three buckets. So one bucket is which is very important, that you need to be very proactive in the enforcement of the things also when there is an infringement and all. So I think that also kind of a collaboration with your system or collaboration with your regulatory regime or your administrative regime, etc. So I think entirely collaboration is absolutely a success in the total dynamics.
I can't agree more with you. With the coming times, there is an increasing amount, the corporate world, we call it, the co-creation. There's too much of co-creation going around everywhere. With that, I will come to probably, we are anyway running late. My last question to say is, if you can very briefly tell us what are the benefits of Haripo, using the Haripo system.
Okay, thank you very much. I think I'll be brief as well based on the time. Yeah, as mentioned, the system is is a centralized system. It means simple. Out of the member state that we have 22 countries, you don't need to file applications through all those 23 countries. Just file one application in our system, through our Haripo system, either a patent, you want to protect your invention, just file one application through our Haripo system, and then you cover all those 22 countries. But mind you that coverage is what called is optional by means the designation. As applicant himself, I can decide out of 22 countries, maybe I'm only interested in 3 countries. So you choose which country you want to be protected out of those 23 countries. So simple to say, because of that, everything goes centralized from a filing application all the way to grant is done in our office. And then when it's granted now or registered now, it becomes registration for all those countries that are part of this protocol. So in that case now, it becomes a bit of simple, cost effective, because now, this is how our IP system works. If we want to go through all those countries, that means you have to go each country, file one application. Then each country, because you are not residents there or citizen, you have to hire for a legal attorney for each country. So in that case, our system is simple to say, you have one application, one agent, legal representative can represent you throughout all those countries, and then it also works through. It processes in one in our office. In that case, now it becomes more efficient. And at the same time, we have 12 trained examiners in our office. For example, in case of patent, that means we have a qualified examiner who are trained from different IP office, and therefore our grant is secured in terms of strong patent, for example, because you have other systems that they don't do substance examination. So in that case, you're not sure whether when you get your patent, you are not certain that this is something that can be enforceable. But in our case, because we have a qualified examiner, so we're going through all the training, all the examination, and therefore when you get a patent, it's strong, it is scrutinized in terms of the product, like what Ashok mentioned about the issue of the claims, all the things. So it becomes stronger and easy for enforceable, and that means now it gives you confidence to the applicant that, okay, I'm getting a patent in this region, it can be enforceable. I think I can stop here because of the time. And I just invite those who really want more detail. We have a booth there. All the information you can always get from there. Thank you very much.
Thank you, Said. Since it's tea break now, I'm taking a little bit of liberty. We can possibly have 1 or 2 questions, very quick questions, very short answers. Looks like we had a wonderful discussion. Everything is clear. There are no questions. So I thank all the panelists for sharing their time and more so sharing their thoughts, which was really, indeed, very meaningful. With that, we close the session. Ladies and gentlemen, have a wonderful evening. Thank you.
Well, what a profoundly insightful session that was. Can we have a round of applause for all our panelists? And I would now request Professor Dr. Anindya Sircar to kindly felicitate our speakers. Um, First, we have Mr. Ashok Narladkar, a patent agent at Cretan Corporation. Next, we have Mr. David Sampson. Next, we have Mr. Jagannathan S. Next, we have Mr. Samit Gambhir. Next, we have Mr. Said Ramadan. I would also request the panelists to kindly come together for a group photo.